Hey everyone, it's Steve here with Entrepreneur Contracts, and today I'd just like to spend a few minutes talking about contract essentials or quasi-essentials, things that I think are worth considering when you're drafting a contract, and also things that are absolute must-haves that really, even if you don't have it, you must consider having it. So, in terms of a strict legal definition, a contract requires a bargain for exchange of legal detriments along with consideration. But more practically, I think how that plays out is you've got to have, a mutual exchange of different values. So, someone has to be exchanging something of value for another thing on the other side. And how that plays out is you want to have a clear identification of who the parties are. You want to have a clear identification of what the subject matter is, what the rights and responsibilities are. And then you want to have a clear signature block that shows that somebody with authority has consented to this agreement. Now, after those literal essentials, in terms of other provisions that are functionally essential that you'll see in almost every contract, are going to be things like your arbitration clause. An arbitration clause allows you to resolve the dispute outside of court in a process called arbitration that's much more cost efficient and less time consuming than litigating and trying a case. And this is basically where a retired judge, usually a retired judge, will basically step in and make a decision based on the facts of the case in a relaxed setting with relaxed rules of evidence. And this judge will issue a binding opinion or a binding decision that will or can be filed in district court and carries the weight of a binding decision from a court. Just a step down from that is mediation. Sometimes you can have a mediation clause, but mediation is very similar to arbitration, except the judge's final opinion is not binding. It's just a suggestion for the two parties. So that's another consideration there. After arbitration and mediation, another thing that every contract basically needs to have is something called a merger clause or an integration clause. These are the same thing. And what these basically say is that all of the considerations of this subject matter, this agreement, are contained within the four corners of the document. There are no extraneous pieces of information or other documents that will affect what is outlined in this agreement. And the classic example of this is, somebody comes back later and says, oh, well, actually, we agreed to modify this, or we agreed to add this in. And it's a classic sort of dispute that comes up between parties. If you have an integration clause, it makes it much more clearer to the court that everything that you considered for this agreement is contained in this document. One addendum that I do like to have that gives parties flexibility and allows them to make changes if they want to is to have a line or two in there saying something like, if we do decide to make any changes, those changes will be in writing and they will be signed by both parties. Then you've got a sort of backstop that allows you to make changes but also protects you from one party coming back later and saying, actually, the agreement had this in it. Another big one is severability. A severability clause gives the court a power to enforce a contract when one provision or part of the contract is found to be unenforceable or illegal. If you don't have this provision, there's a chance that a court could find one little line in your contract and basically come back and say the whole thing's unenforceable because that one line is unenforceable. So if they have this clause in the contract, it gives the court the ability to say the rest of the contract is still enforceable, even if that one line isn't. So that's a really powerful tool to allow contracts to be a little more hardier and able to withstand scrutiny. The next one is a choice of law provision, and this decides where the dispute will be resolved. And so it's kind of related to the arbitration provision in that it's deciding what sort of remedies are available between the parties and where it will be decided and which law will be used. So choice of law sort of plays out in a few different ways. It says we'll use the laws of a particular area, but then there's also a sort of wrinkle in it where you've got things like, a forum provision that says this is where all of the disputes will be resolved. So both of those things are considerations. Generally, people want to have something in the contract that says we're going to resolve this dispute in my home state. And that makes it easier so you don't have to find a lawyer in another state, you don't have to travel, you don't have to find out what the laws are in another state. Now, sometimes there are occasions where another law or another state has laws that are more beneficial for a particular person or business. And so that's another thing to take into consideration with choice of law or forum provisions as well. Now moving down in terms of importance to a sort of section that I'm calling quasi-essentials. You won't see these in every contract, but they're still very common and worth considering if not having in there. That's going to be something like a notice provision. So a lot of times in a contract, you'll need to exchange information, or if one party wants to, terminate or discontinue the contract, they need to communicate that intent in writing. And so if you don't have a clearly outlined notice provision, it's unclear how the parties need to transmit that information. So then you could run into these situations where, somebody wants to terminate the contract, they send an email to an old dysfunctional email, the other party never gets it, they send an invoice or whatever the next month, and then you've got this dispute. If you have a notice provision, it allows you to say, okay, if we're going to make an official exchange of information with respect to this contract, it's going to be through certified mail, or it's going to be through this email. So the parties know I can't just let this email go defunct or stop checking it. It's going to be our official way of letting each other know any number of things in terms of how we're going to interact with respect to this agreement. The next one is a mutual representations clause, and that's really important because it basically says, we are who we say we are. You don't want to run into an issue where a corporation or a business sends a delegate to go sign an agreement, and actually it turns out they didn't have the authority to enter into an agreement with respect to that amount of money or this particular issue. So if it's a big agreement, you might need to have the CEO or the COO or somebody of that level to sign it. If you've just got, a sort of assistant to the assistant, you could run into issues where, they come back later, a board member or a CEO says, hey, I never gave anyone the authority to be able to do that. And so mutual representations clears that up a little bit. Another one is assignability. Are the rights given in this contract able to be assigned to someone else? A lot of times you don't want that. You don't want the other party to, procure the benefits of this agreement and then be able to say, oh, well, I'm assigning all my rights and benefits under this contract to some other party. So I think even if you don't have an assignment clause in there, it's worth considering having one, or how that might play out if the other side decides to start assigning their rights or duties. The last one of these sort of quasi-essentials is one I'm calling waiver. And this has to do with whether or not a small, overlooking or failure to exercise a right in a contract will mean you waive that right in the future. And this is worth noting. I think when people hear waiver, they're automatically thinking like, you're going on a zip line and you sign a waiver, so if you get hurt, you can't sue them. This is a little bit different. This is saying in this agreement, let's say there's a provision that says if you're late with your payment, there's a 10% late fee, right? Well, the first time or two that one party is late, the other party doesn't say anything. They don't enforce the late fee. Well, then the third time they want to enforce the late fee. If you don't have a waiver provision in there, theoretically the party that's being benefited by paying a little bit late and not having to pay the late fee could kind of come in and say, oh, well, in the course of performance or in the interactions that we've had so far, we haven't enforced the late fee, so that functionally becomes the agreement. If you have the waiver clause, you can avoid that sort of thing happening. It says, even if we do this one time, it doesn't waive our right in the future to avoid the late fee or not assert the late fee. Now moving into sort of general considerations with contract drafting, not so much specific terms or provisions or essentials of a contract, but just sort of themes or things to keep in mind when you're drafting a contract. For me, a big one is plain English. Try and use plain English as much as possible. This doesn't mean to dumb down the contract. If there's a technical term that you need to use, you should use it. But in general, if you can say something in a similar way, it's probably beneficial to do that. There was a trend in law over the last 30, 40 years, maybe a little bit less, maybe 20, to go from these sort of very archaic terms like herewith, therefore, herein, to more simple English that anyone can understand. because really it doesn't benefit the parties to have unnecessarily difficult or lofty language. Really, it's in everyone's interest, including the lawyers and the parties, to be able to understand and interpret this contract as simply and easily as possible. It's time saving. It allows the parties to know what they're agreeing with. And so this is really an empowering tool, because you can understand, if you're drafting a contract, you can be simple. You don't have to try and sound like a lawyer. You can say what you want to happen, and generally the court's going to do their best to give the effect to the contract that they think the parties are trying to do. The next one is a big thing that I think can be forgotten in sort of nailing down the particulars of a contract is, what's the point of it? Why are we making this contract? And along with that, it's assessing risk. What are the risks that can come up between this beneficial relationship between the parties? You want to be thinking about the different hazards that could come up in this relationship, because that's sort of why you're outlining an agreement in the first place. So, if one party's a photographer and the other party is, oh, I want to have a shoot at this location, and they didn't get permission to get the shoot there, is the photographer going to be liable for that? Those are the kind of things you want to think of. So maybe the photographer wants to have a little provision there in there that says, hey, if you're going to pick the location, you agree to make sure you get the legal permission to do that. And if you don't, and there's a penalty, then you, client, are going to pay that penalty, not me. But that's a really beneficial thing to think about. Why are we doing this? What are the risks? What are the potential pitfalls for what we're about to try and do together? Another one is payment. You want to think about how payment is going to happen. What's the structure? Are there late fees? Do you get half up front and half when the job's done? If you don't outline those sort of structural elements, payment can get sticky. I think a lot of freelancers or independent contractors or small businesses deal with this when there's not a clear outline structure of how payment's going to be transmitted and when it's going to be transmitted. You want to be thinking about, who, what, where, when, and why, kind of your classic, journalistic, ideas of all of the different things that come into play when you're talking about payment. The last one, I think, has sort of been covered in other areas, but is worth bringing up again. And these are limitations of remedies, limitations of liabilities, and disclaimers. When you agree to have a contract with another party, there's things you want to think about in terms of unforeseen circumstances. So a classic one is a disclaimer. With a disclaimer, you're basically saying, this is how the product is being delivered. Either a product or service, I should say. Either you're saying, I'm going to give you some kind of warranty, or you're saying the product as is, basically. Now, there's some more wrinkles besides that, but that's sort of how it lays out. And so you want to think about, if someone buys my product or service and misunderstands what I was offering, do they have an ability to seek a legal remedy? Because, for example, a chair. You're selling a chair. There's what's called implied warranties of merchantability, or implied warranties of fitness for a particular purpose. Something like, if you sell a chair, there's an implied assumption that, an average sized person is going to be able to sit in that chair and not have it collapse. That's sort of the implied warranty for a fitness for a particular purpose. You can disclaim that and say, hey, maybe I don't want to have that sort of guarantee that you're going to be able to sit in it. But then people might have a different perspective on your product. They say, oh, they're kind of not willing to stand behind it. So these are just sort of considerations that I think are worth pursuing before you just sort of sign your rights away and say, yeah, I didn't think about implied warranty of merchantability. And so now somebody could potentially have that claim. Or, I disclaimed it. I said, you are waiving your right to this implied warranty of merchantability, but now consumers might have a different view of your product. So all those things working together sort of give you a brief overview of how contracts work, important things that contracts need to consider, and absolute essentials for a contract. I know that might have been a lot to swallow, and you're thinking, boy, do I really need to know all of this? What I would say to that is, first, a lot of this is finite information. It seems like a lot, but you can spend an hour or two with this and really have a pretty good idea of sort of contract fundamentals. And it's going to give you a huge leg up in terms of contract negotiation, drafting, leverage with people when you're making agreements with them. If you just have a working understanding of this stuff, you don't have to be an expert on arbitration clauses. But if you just understand what an arbitration clause is and how it might benefit you or hurt you, I think you're a lot more empowered when you're entering into agreements with other people. So I hope you found this contract workshop informative. And if you have any comments or suggestions about this particular video or things we could add in future videos, please reach out to us at support@entrepreneurcontracts.com. Thanks so much for tuning in.